get started, apologies for the technical difficulties. My name is Alanna Kane. I'm a Greenberg Fellow here at the law school. I'm a CRS alum, class of 2022. It is such an honor and a privilege to be here today. I always say that I'm a child of CRT, and so it's really just a dream to be back here. How this concurrent session will proceed is I'm going to do a little bit of sort of situating what the discussion is going to be today, and then I'm really just going to hand it over to our illustrious panel. They'll give pretty brief presentations, and then we'll proceed with the Q&A. And so we're here today and to talk about reinscribing whiteness, law, power, and the evolution of white supremacy. In his first joint address to Congress, former President Biden called out the most lethal threat to our homeland today, stating that white supremacy is terrorism, and that we must come together to heal the soul of our nation. Most recently, the Department of Justice, under the Trump regime, quietly removed a recent study that revealed that white supremacy is outpacing all other forms of terrorism and extremism in the United States. We no longer face the threat of a second redemption. We are living under its reality. So what exactly is white supremacy? And maybe for our purposes today in this brief concurrent panel, I want to offer an explanation on what the term white supremacy is not. So it's not simply a descriptive term that refers to the domination of whites over non-whites. It is not a corrosive ideology, divisive concept, or anti-white reverse racist claim that aims to make white people feel bad about themselves. It is not a fringe, radical, leftist tactic to spread disinformation or a distorted narrative driven by ideology rather than truth. To quote from the President's executive order on restoring truth and sanity to American history. And it is not, by any means, a framework that exists outside of law over there, but it is reified, reconstructed, and reconstituted by and through law. So we're in a law school. Let's provide some definitions. I rely on philosopher Charles Mill's piece on white supremacy as socio-political system to account for the magnitude of white supremacy's reach into every aspect of social, economic, and political life. So white supremacy, it's an inherently political concept. It's an active heuristic. It names the ruling hegemonic group, whites, and calls out its means of subordination, supremacy, the act of being highest in rank, authority, or power. Deliberately employing the term white supremacy, quote, registers a commitment to a radically different understanding of the political order, pointing us theoretically toward the centrality of racial domination and subordination. So where does that leave us? We can think about white supremacy as the socio-cultural, political, economic, and legal doctrine of racial domination, control, and extraction across systems of power and authority. It's a mouthful, I know, but that is to say that nobody and no particular thing has escaped the tentacles of white supremacy. It's simultaneously a system, it's a structure, an ideology, a relationship, a property interest, as Cheryl Harris notes as well, and a currency. So CRT as a school of thought and a body of knowledge questions the intellectual assumptions of white supremacy in law. It's a discipline that challenges racial orthodoxy. It shakes up the legal academy, questions comfortable liberal premises, and it leads the search for new ways of thinking about our nation's most intractable and insoluble problem, race. It's against this backdrop I want to situate our conversation today. So today I'll be joined by interlocutors who will explore the shifting strategies through which white supremacy adapts, sustains itself, and reasserts dominance in law, politics, and culture. They will bring comparative and interdisciplinary insights to trace how whiteness is preserved across contexts, from claims of white victimhood in the United States and South African equal protection jurisprudence, to the commodification of identity on social media, to the deployment of religious liberty as a tool of racial retrenchment. Together, these interventions interrogate how whiteness functions both as property and ideology, co-opting even the language of critical race theory to shore up white grievance. By analyzing these dynamics, this panel sheds light on the collective costs of white supremacy and highlights how legal discourse, constitutional principles, and public narratives continue to reinscribe whiteness as normative. So, with that, I want to turn to Daniel Kiel, FedEx Professor of Law and Director of Faculty Development at the University of Memphis, Cecil Humphreys School of Law, to kick us off. So, Daniel, thank you.
Thank you. After that, I actually wish that I was in the audience. Now I have to live up to that framing. I'm also really excited to hear from my co-panelists, so I'm going to try to err on the side of being short, although I don't usually do that very well. So I want to begin by setting out just a way that some people might describe things in our country. Some people might describe our country as being a place where there are structural and systemic forces working to disadvantage an identifiable segment of society, that structure runs counter to professed principles about justice and equality, that structure subordinates people, that it weaponizes law, that it weaponizes culture, in order to create a hierarchy of winners and losers that sustains itself, and that it doesn't rely on individual actors to do this. It, in fact, just does it as part of a systematized process. Now, that description should sound familiar in this room, right? That's a description of some of the core tenets of critical race theory. But what I'd like for us to explore today is that is a direct argument that is being made about the world that is subordinating white people. And so my contribution, or what I'm suggesting, is that some of the tools, descriptive tools, maybe even some of the remedial tools that critical race theory has sharpened over the years are being employed today by people putting forth white supremacist ideas. And I think there's great danger in that, because I think that there's a danger that these tools, that these arguments, and that these principles might be corrupted by that process. And so I think it's important for us to acknowledge. So that's sort of what I'm trying to accomplish today. I think there's also a sort of double irony in the use of critical race theory ideas to promote white supremacy. And it's an irony that is both in that it's coming at a time when critical race theory is being demonized in many places. In fact, the demonization of white supremacy of critical race theory is done in service of white supremacy in a critical race theory way. And second, in some ways, this inversion, the use of critical race theory principles to argue essentially against critical race theory values, almost proves the point, right? If we are going to put into law, in the name of uplift of white people, certain laws and policies, then it's almost driving home the point of critical race theory and systemic discrimination or systemic racism. Okay, so I'm just going to go through sort of quick overview of my thinking on this. I'm going to begin with some acknowledgement that this isn't totally new, that the co-option of anti-discrimination or critical race theory ideas by a majority group is not something that has never happened before. I'm going to highlight a couple of modern examples, first focusing on rhetoric and noting that the use of rhetorical devices and narratives that would be familiar to a critical race theorist, but that's being employed in a totally different way, is not accidental, it's deliberate. And then some ways in which that rhetoric is making its way into policy, which I think probably many of us can already imagine how that's showing itself as well. I'll identify a couple of dangers from this and a couple of thoughts for moving forward. Not a fully formed paper at this point, so early in the project, so I look forward also to feedback. The law students and the lawyers and the law professors in the room will perhaps be familiar with the quote from 1883, the civil rights cases, less than 20 years after the Civil War, less than 20 years after the 13th Amendment and the 14th Amendment and the 15th Amendment, in which there was already impatience with the use of remedial action for racial uplift. And I'll just read the quote from the civil rights cases. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. So already the idea that remedies are in fact a form of discrimination. This is something that pops up again and again. It is something that I have a quote in the paper from President Nixon in the early 70s and sort of aftermath of the civil rights movement, in which he's trying to sort of neutralize the idea of discrimination, but it's probably most famously put for our purposes in the Parents Involved case in 2007 by Chief Justice Roberts. That's a K-12 integration or diversity plan case. And Chief Justice Roberts says the way to stop discriminating on the basis of race, or the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And so this equivalence of discrimination in the past to discrimination now that is disadvantaging white students. But what I suggest is that what we're looking at in this particular moment right now is different than the past, in that we're not seeing just individual claims like from an Alan Bakke or a Jennifer Grutter, the affirmative action cases, the plaintiffs, saying I individually was discriminated against. We're seeing a much more intentional, systemic argument being made. Okay, so I want to highlight a couple of things that are current. So that was the backstory. And note that the rhetoric, when we're dealing with this, is using the systemic frame. It's a systemic discrimination against white people, the use of narratives to elevate that frame, and attack on neutral phrasing. Neutral phrasing being not as the claim is that it's not as neutral as it sounds, or it's not as nice as it sounds. So perhaps it's already in your minds, the idea that woke is a form of racism, or that there is such thing as a woke ideology that is taking over the United States. It's been called a structural force that is being enforced, through government, education, business, and culture. The book calls it woke racism and speaks of it as though it is a religious system, almost a religious ideology. Where do we see these kinds of rhetoric showing up? We see this is the claim. The claim is that wokeism has infected school curriculum, corporate diversity training, government anti-discrimination policy, government enforcement of anti-discrimination, And the claim is that it is not individuals who are woke, it is a broader system that is woke, and that is what must be confronted. So we see it, I've mentioned the woke racism book. There's another book called The Unprotected Class. In that book, the unprotected class is white people. This book by Jeremy Carl, which was highly promoted in, I guess, white supremacist circles, but I think that circle is enlarging. Some of the quotes: anti-white racism is the most predominant politically powerful form of racism in America today. Anti-white racism, undisguised and unembarrassed, is now official policy in America. And I would note that this is not an accidental inversion of language. In the previous panel that I just sat in, I know that not everybody was in the same thing, there was a reference to Christopher Rufo, who has sort of been the lead proponent and architect of the anti-critical race theory movement and legislation, who makes some of the same claims about critical race theory being an ideology that's being imposed in all these different ways. But he provides a guide to individuals that he would like to activate to go to school boards or legislative lobbying sessions, etc., and push this argument. And he says in this guide, the critical race theorists have constructed a series of powerful linguistic tools. To successfully fight against critical race theory, we must adopt language that is trenchant, persuasive, and resonates with the public. And then there's a long list that he provides of the way in which you should talk about this in order to be persuasive with the public. And it's not just language, it's stories that he's after. He goes on, the strongest line of attack against critical race theory is to cite specific stories about critical race theory in practice. When you're designing your communications, so it's very strategic, weave in stories about the reality of critical race theory in American institutions, and then he has a database of 1,000, more than 1,000 stories about critical race theory and how it's used in a school setting, in government, in businesses. And so I don't believe that the inversion is accidental. I think it's deliberate co-option of these ideas. And it's driving law and policy. So I would note briefly, one might say this is a slight departure from critical race theory, which I think would argue to operate outside the bounds of the established institutions. Clearly, this movement is operating in a way to within those institutions. So it might be a little bit different. But I guess I would suggest the mass firings, the total dismantling of the Department of Education, and various other things suggest that maybe it's not about operating within the institutions as they exist, but it does have a sort of tear it down kind of element to it. So we see it informing policy choices, litigation strategies. They're using these narratives, and they're relying on statistics to move discussions away from individualized acts of anti-white racism and towards systemic anti-white racism. We see it in the executive orders, some of the movement on the Department of Justice enforcement of Title VII regulations, noting just briefly that there's an intersectionality here also to, I think, one of the panelists is going to speak about the connection to religion. I think there's a sex-based intersectionality here when we talk about the prioritization of protection for the accused, those who have been accused of sexual harassment, and so we see that as well. And a variety of litigation tactics, and so obviously after SFFA there's more reverse discrimination suits than there have been, etc. I'm at time, so I'm going to stop here and hopefully mention some of the reasons I think this is particularly pernicious and dangerous in the Q&A section. So thank you.
Thank you, David, for those session comments. So I want to now invite Ohene, Ampofo-Anti, Yes?
Yeah,
Okay.
yeah.
A researcher at SAIFAC and a UCLA Law LLM class of 2019 to invite your contribution.
Well, good afternoon, everyone. It's really a pleasure to be all the way on the other side of the world here. Back at my, my former law school. I graduated here in 2019 under the Critical Race Studies program. Now based at SAIFAC, which has a very long name, so I'm not going to say it, which is affiliated with the University of Johannesburg. And Daniel's done a very good job at already laying the groundwork for what I'm going to be talking about. But my intervention is kind of around how white victimhood is being used as a way to shore up white supremacy. And Professor Harris and others said yesterday that we're in a moment of backlash. Thank you for switching off the Hollywood lighting. Thank you for switching it off. So yeah, let me begin my address. So earlier this year, the White House issued an executive order denouncing the so-called egregious actions of South Africa, such as the seizure of white Afrikaners' property without compensation, which it claims will dismantle equal opportunity. Refugee status has subsequently been bestowed on Afrikaners with accusations that South Africa is committing a genocide. I've heard that these refugees are now being called Amerikaners, hopefully not spelled the same way as the eponymous novel by Chimamanda Ngozi. Meanwhile, in South Africa, the Democratic Alliance, which is the biggest opposition party to the ANC, has filed a court challenge against new employment equity laws in South Africa, which impose numerical targets to be achieved to transform business sectors. And they argue that this is a grand social engineering scheme, and that instead of tighter or stricter affirmative action laws, we must grow the economy, create jobs, and improve education for black people, which is what they argue. And what unites these attacks on racial redress measures is that they raise the specter of white victimhood under the color-blindness, which is something I've alluded to quite well, how it's being turned into a kind of systemic discrimination against white people. That is the actual issue, but ironically, formal equality is now used to achieve anti-subordination against white people. And so white victimhood is preoccupied with the idea of redistribution along racial lines. And because redistribution entails burdens for those who are privileged and taking those privileges away from them, proponents of white victimhood attempt to draw a moral equivalence between racial redress and historic racist injustices such as slavery and segregation here in the United States or apartheid in South Africa. And in doing so, proponents of white victimhood seek to disentangle race from racism and the past from the present. They seek to argue that a nation is made up merely of individuals, some who work hard and reap the rewards, and others who don't work hard and are less deserving. And contemporary racial disparities, both here in the United States and South Africa, in wealth, income, employment, access to services, these are simply irrelevant, because there are no groups in society, according to this white victimhood approach, let alone racial groups. There are only individuals, and in a nation, people must be treated equally as individuals and not members of racial groups. So in this address, I'll try to distill what we can learn from white victimhood and its closely related ally of color-blindness, and the ways that the constitutional right to equal protection is being reshaped to thwart attempts at racial redress in the US and South Africa. And I want to echo what Daniel was saying, that these ideas that I'm articulating here are not new. They come from a long tradition, and I'm merely describing or trying to make sense of what's happening at this moment of what people are calling backlash. So I'll begin by recalling Lawrence Tribe's remarks on color-blindness and how he distinguished what he called an anti-discrimination approach from an anti-subordination approach. And Tribe argued that there are two interpretations of Brown versus Board of Education. In Brown A, all race distinctions are prohibited and regarded as inherently unequal. But in Brown B, the main purpose of the 14th Amendment has always been to ban the use of law to subjugate a racial group. And Tribe said he could only think of one constitutional command that the race neutralists might invoke to justify Brown A command that law and government must not restrict any innocent individual's liberty, even when such a restriction is justified by a desire to protect others who are equally innocent. So this old argument about the burdens of racial redress has resurfaced and now won decisively in Students for Fair Admissions versus Harvard. Because according to the majority by Roberts, the import of Brown and his progeny was that the core purpose of the 14th Amendment was to do away with all governmentally imposed discrimination based on race. And just as others have pointed out, by discrimination, they actually mean the use of racial classifications. And Roberts says eliminating discrimination means eliminating all of it. But here, racial redress measures are included in the definition of discrimination. And so Tribe then contrasted this anti-discrimination approach to an anti-subordination approach. And this approach would be where the Equal Protection Clause asked whether the particular conditions complained of, examined in their social and historical context, are a manifestation of a legacy of official oppression. And what we see in SFFA, I'll just use that as a shorthand for Students for Fair Admissions, we see an anti-discrimination approach where the court argues that because admissions based on race say that black people all have a similar point of view, ironically, racial redress measures now are demeaning to black people themselves. So meanwhile, in South Africa, those who seek to delegitimize affirmative action cast Miss Barnard, who was a plaintiff in a case, who was a white woman, who had been turned down for promotion twice in the South African police service, and they cast her as a victim of affirmative action policies. But thankfully, the Barnard case, the Constitutional Court's main decision on affirmative action, actually embraced an anti-subordination approach. How am I doing for time?
5 minutes.
Okay, so I want to go through a few points because I'm trying to contrast the approach by the Constitutional Court of South Africa to the Supreme Court. And the 3 points that I'll be covering are what I call rewriting the past to reshape the present. Secondly, what is the goal of equal opportunity? And thirdly, the idea that color-blindness is always a norm, except when it isn't. So, in rewriting the past to reshape the present, or what I wanted to call sort of back to the future, you can think of it as a sort of right-wing Terminator, where Sandra O'Connor is sent back to delete references of racism so that racism doesn't matter in the present. So the majority in SFFA say that barring Plessy, what was always sought was color-blindness. And in doing so, it empties Brown of meaning and strikes this moral equivalence between segregation and affirmative action. Justice Thomas's opinion, his concurrence, is even worse. He goes as far to argue that the Freedmen's Bureau applied to freedmen and refugees. And he says, quote, because not all blacks in the United States were former slaves, freedmen was a decidedly under-inclusive proxy for race. So he then says that basically, even at the time of Reconstruction, essentially race neutrality or color-blindness was allegedly the law, what you alluded to in that quote from the civil rights cases. But we see a different approach in the Constitutional Court's decision in Barnard, where the court actually acknowledges how race under apartheid was central to how inequality existed, and therefore it is central to how inequality should be remedied in the present. The second issue is the goal of equal opportunity. In SFFA, the majority regards admissions as a zero-sum game. Because affirmative action will necessarily advantage some, Roberts regards it as inherently burdensome to others. Justice Thomas's concurrence, meanwhile, argues that the 14th Amendment's goal is to render the color of a person's skin irrelevant to that person's individual equal status as a citizen. And people should be treated again. There's this whole like weird logic where it says that people must be treated as individuals and not members of racial groups. And that because affirmative action harms beneficiaries because it is demeaning to them based on stereotypes, and it is also an injury to those who supposedly lose out. So here, the goal of the Equal Protection Clause under SFFA is to essentially do away with any notion of racial classifications and to create a society of individuals free of racial identity. And so this is actually identified as the main goal of equal protection. But in Barnard, in the Constitutional Court's decision, by contrast, equal opportunity is cast as transformative. And the court says that the equality clause in South Africa's constitution should reimagine power relations within society. And that to the extent that affirmative action measures burden those who are privileged, it should simply not unduly invade their human dignity. And the key word here is unduly, for it is presumed that affirmative action will impose burdens. They just shouldn't be disproportionate. I'll then touch on colorblindness is always the norm, except when it isn't. Now, at the end of SFFA, Justice Roberts says something very strange. He says, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And then he cautions, but the student must be treated based on his or her experiences as an individual, not on the basis of race. This is probably the most telling part of the entire decision, because essentially, it is only a white person who can so easily disentangle race from their so-called lived experience or inspiration. And so it shows that colorblindness is really just shoring up whiteness as a baseline, and it's actually less honest than an anti-racist approach or anti-subordination approach about when race does and does not matter. So it's trying to play this game saying race is irrelevant, but actually sometimes it is relevant. So in my last minute, so what does this reboot of colorblindness under the banner of white victimhood mean for racial redress policies today? So the approach in the United States and South Africa is slightly different. But what unites them is that these people don't like being called white supremacists. They wouldn't want to be called racist, ironically. But they advance arguments around white victimhood and the necessity of colorblindness to protect the constitutional right to equal protection. And they use this formula where they actually want to abolish racial groups and de-racialize individuals. And I just want to end by mentioning that while South Africa's Constitutional Court has largely defended affirmative action, legal scholar Nomfundo Ramalakana argues that organizations defending white supremacy in contemporary South Africa have been successful in diluting the constitutional protection of affirmative action measures and other laws aimed at racial redress by heightening the level of judicial scrutiny applied to such cases. And so in closing, as racial justice advocates, we must remain vigilant and alive to attempts to reboot white supremacy. A rose under any other name is still a rose, and now more than ever, it is necessary to call a spade a spade. An anti-subordination approach has never been more relevant and essential to peace through when race does and does not matter, and what the true goal of equal protection must be. Thank you.
Really rich to see, how the continuation of how Daniel is situating, white racial grievances and white victimhood and how that's taken up and, contested within the South African context, and doctrinally, what that offers at this particular juncture. I want to turn next to Brooke Girley, who's an assistant professor of law at Delaware Law School.
Sorry, the mic has to come back on.
I'm in Hollywood again.
You're back in Hollywood, down the street. much for being here. Thank you. It's a privilege to present at this wonderful conference. And so my interests are at the intersection of race, religion, and the law, specifically how religion is used to both oppress racial groups and how racial groups use that to liberate themselves. So for the sake of this, I'm talking about sanctifying whiteness and sort of how religion is used in the subordination process. So when I started this project, before I started this project, this wasn't, he wasn't an issue, but this happened. And I wanted to raise his death because I think it's an important way to look at how religion functions, religion and race functions in this country. So obviously, Charlie Kirk, if you don't know who this is, Charlie Kirk was a very, I would say, racist person. He would go around campuses arguing with people, debating college students, and then unfortunately he was killed. And in his death, what happened afterwards is that a lot of people started to see him almost as this Christian martyr, right? He was labeled this Christian martyr, he was given this saintly order, and so in hearing all this, I think one congressman said that he was like the 13th apostle. He should have been right up there with him. And I began to think, so I put out a video on social media just challenging the notion that he was a Christian as he purported to be, or what people were saying, by using his own words, right? I just used his own words. And when that happened, a pastor that I know, a white pastor, reached out to me, slid into my DMs, and he said, not in a good way. He slid in and he said, I saw your video, can you please provide why you think he was racist? And I was like, absolutely, I provided all the receipts. And then he responded with essentially that I was taking Charlie Kirk's words out of context, right? And I was like, and so we're going back and forth, and I'm like, if I tell you that his words are offensive, why are you, trying to challenge me? And so then I began to think, what is actually happening here? And it spoke to the way that religion is used as a shield for white supremacy, right? I'm not racist, I'm a Christian. I'm just purporting to do what I want to do. But it's also used, as Charlie Kirk was using it, as a sword to perpetuate white supremacy, because he's going around and he's saying these things in the name of his faith. And what we see is that there's often, historically and presently, a conflation between whiteness and religion, but really specifically Protestant Christianity. So when I say religion and religious freedom, it really is Protestant Christianity. That is the normative baseline here, and that's always seen as being white. And so because Christianity is used as this shield, that is why this pastor felt the need to then defend it, because he's defending his faith. And what happens is whiteness proper is seen as being Christian, and then Christianity proper is seen as being white. And so when one is attacked, the other is attacked. When one is asserts its power, the other one is asserting its power. And so this dual function, there's really then this dual functioning of religion in society. And the dual function is, one, again, religion is used to mask blatant racism. That's how it functions. But then it also is used to have this whiteness and religion is used as interchangeable terms. And so again, the assertion of power of one is seen as the assertion of power in the other. And that becomes important when you see the expansion of religious liberty recently in the Supreme Court cases, where the Supreme Court has literally given all these religious liberty claims their right. And I think that is also an extension of the expansion of white supremacy. And this has both historic and present roots. And so what then religion is used as a tool of white supremacy in society. It allows white supremacy to do what Michelle Alexander called shape-shifting, right? It's able to use language and do different things at different times. And so this project looks at that both from a historical perspective, looking at slavery, looking at the civil rights movement, and then also looking at what does that mean for today. And so those are the two periods that I want to kind of just briefly, because I know we don't have too much time, talk about American slavery, the civil rights movement, and then what can we learn from today. So if you're starting with a historical perspective, right, you have to start with this notion of the heathen as a precursor to the term race. Before there was race and racism, there were heathens. And what does heathens do? What does that word heathen do? And it predates American society, right? But what the word heathen does is it creates this category of the other, right? You are the other. So now it marks you. Not only are you black, but you are black and heathen. you are Native American, and you are heathen. And you're something that's very distinct from white culture, right? You are everything non-white is considered heathen, and everything that is Christian proper is considered are whites. So even if you assimilate and try to create yourself as a Christian instead, or Christian people, like the Native American Shaker, or the Indian Shaker Church tried to do, you're still not seen as properly white or properly Christian because you are not white. And so what this classification, again, heathen does as a precursor, is it creates the superiority of white people, because they're the people who are not heathen, and then it also gives them an excuse to dominate other groups of people as well, because I need to civilize you, I need to sanctify your soul. And so then later on, the term heathen gets replaced during slavery, and so no longer are we using heathen exclusively, but we're also using that with race. But you still have religion in the backdrop justifying this distinction. Those distinctions between whites and non-whites is still there. And you're still using slavery, using religion to justify slavery. So for example, you have the Hamitic curse. And I don't know if anyone's familiar with the Hamitic curse. So the Hamitic curse was this idea that from the book of Genesis, where Noah, after the flood, his son Ham sees him drunk and naked, and he laughs and makes fun of him. Noah wakes up from his stupor and is like not happy with that, and curses Ham's son, Kane, and said, you will have to work for your brothers. And so from there, white Christians say, okay, well, black people are the descendants of Ham, and therefore they are the ones, that's why they are slaves, because they have been cursed after this, following this. And of course you have, again, the word heathen. But what also happens here, as slavery begins to meet abolitionism, you have them use this religious liberty language as an excuse, because they can't be overtly racist in the same way. So then you have this idea, what Tisa Winger says, is this individual consciousness, that I have the right to believe what it is that I want to believe. And so the pro-slavery faction then replaces this, again, overtly racist thing and says, we detest abolitionism, as one pro-slavery person said, we detest abolitionism because it trespasses our rights of consciousness, our right to believe what we want to believe, right, our religious liberty. It does not allow us to judge for ourselves the morality of slaveholding. Now, it speaks nothing about the slaves' religious right, their moral liberty, but they're framing this as, this is my religious freedom to be able to decide for myself whether or not I want to hold slaves. And they saw a sacred right of slavery as something that was divinely ordained. And what's also interesting here is that, and kind of building off what you all were saying, they're using their faith to label the abolitionists as the oppressors, right? And to say that you are oppressing me based on my religion, but really what it is you're oppressing me because I want to enslave black people. You see this continue to happen. The same thing happens during the civil rights movement. So you have Brown, white supremacy loses its mind, it's in a tailspin, and it's trying to figure out what to do. And this, again, you have the use of religion to both mask racism and to assert power. And you have segregation, obviously, is on the decline, and because it's on the decline, they realize, again, they cannot be overtly racist in the same way. So then they create this, thank you, segregationist theology, what J. Russell Hawkins calls a segregationist theology that excuses, again, explains their position. Whereas before you had players who were saying things in a very racist and overtly racist way, they changed their language to language that is religiously focused. As Tisa Winger says, throughout the 1940s and 50s, segregationists regularly invoked religious freedom alongside the freedom of choice and the freedom of association to defend racially exclusive schools, neighborhoods, and workplaces. So that's how you get a quote from a U.S. District Judge, George Bell Tinnerman, when he wrote, I believe that God knew what he was doing when he created the races and separated them, just as I believe he knew what he was doing when he created the beasts of the fields and the birds and gave them instincts. So again, he's saying, I'm not racist, I am just saying this is my theological position. And then as it progresses, the use of overt racism is lost and the idea of religious liberty is promoted, such that segregationists like Donald R. Richburg insisted that his position was, quote, not because of any narrow prejudice, but because of profound religious conviction. Again, so I don't want to integrate, not because I don't like black people, but because my faith tells me I'm supposed to be separate, and I have this religious liberty, this right to remain separate and apart from that. So what happens to that? What is the result of that? Well, you end up getting, and this is a strong term, but what you end up having is that there's a circumvention of the integrationist efforts that's happening. So there's a rise in private schools, there's a rise in religiously funded private schools. And again, because we're couching this in non-racial language, you have someone like this, and this was a father who wrote to Strom Thurmond, that's Strom Thurmond, who was asking Strom Thurmond to push for these private schools. He said, this father wrote to him and said, quote, "Without freedom to choose for our children to go to non-public schools with black people, then there is no freedom of religion." So he's linking his ability to segregate himself and his children with his religious freedom, right? So that, again, there's that language, that parallel. And so as a result, the legacy of this, and here you have exceptions, school choice, and then color blindness that are a result of this history and tradition. As I said before, you have school choice, the rising of private schools. Even currently, though, we have the rise of charter schools and school vouchers. They're all tied into this legacy. Even St. Isidore School, the case that was just, I think, in April of this year, where the Supreme Court ruled it was a split, so they didn't actually vote that you can have public funding for private or religious charter schools. But the court seems very ready that if another case were to come up through the ranks, that they would actually rule that you have public funding for religious charter schools. So you have that, they're circumventing their civil integration. You also have the rise in colorblindness and colorblind language, which is my colleagues have been discussing. That also comes again because we're not using race, we're using religion, and we're going around that. There's this focus on the family. Again, I have the right to be able to choose for myself where my children go to school, and I want them to go to great schools, and great schools are schools that are not integrated, right, where black people are not there. And then finally, you even have the rise in exceptions beyond just the scope of schools. You have that in the education setting. So in Title VII cases, employment discrimination, you have the rise of something called the ministerial exception, which allows you to discriminate against, so religious institutions, which is broadly construed, they can discriminate against any employee that's considered a minister, which again is broadly construed because the two cases, Hosanna Tabor and Our Lady Guadalupe, they were teachers. And the court called them ministers and said that you can discriminate against them even if it's not based on your religious beliefs as an institution. And so you have these exceptions that circumvent and undermine civil rights, and I know I only have 1 minute left, less than 1 minute. These are also, so those are the ways that you mask overt racism, that religion is used to mask overt racism. I also would say in my final seconds that you also have, again, religion allowed white supremacy to assert its power, and I would suggest to you that all these cases, this is Town of Greece, the School of Prayer, this is the Praying Coach, American Legion, the Big Cross, all of those cases where the Supreme Court allowed for religious liberty to be expanded really should be seen as an assertion and expansion of white supremacy. And we see the same kind of language used in society. You mentioned about what's happening in South Africa. There are religious podcasters talking about that as a reason why white people are under attack and how religiously they have to do something about that. And so it's all cyclical, where now, again, you started with heathen to race, and then you let go of race, and now we're going back to religious reasons for what we're doing. Thank you.
Thank you very much, Brooke. I think, where we're at so far, we have had some really rich discussions about how white racial grievance has been articulated, in law. We're now kind of seeing how it's been weaponized through religion, through religious freedoms, through the culture wars, and now we'll proceed sort of with social media as well with Rashaya Ghee, who joins us, is a visiting assistant professor at the University of Minnesota Law School. So with that, Rashaya, get your slide.
One last time with the light. Thank you. I really appreciate this opportunity to talk through. I want to echo something a colleague said earlier. This is in the very, very, very early stages, the earliest stages. So I absolutely invite all the feedback. I'm really excited about the opportunity for the exchange. Okay, so part of what I think is happening here is we're seeing a decline in the value of white supremacy at a global level, right? And I think that there's a myriad of reasons for that. Some of which are the work that CRT has done in articulating and giving language and framework to analyzing how race actually operates. I think as the civil rights movement has created opportunities for visibility, for ingestion of Black culture, and I think all of these things at a global level are challenging the rectitude and hegemony of whiteness as it has existed, right? It is challenging and interrogating the value of white supremacy, and there are a couple of ways I think that this is manifesting. I'm thinking about, there was a recent article at Harvard Business Review that they studied 14 social justice movements over the last decade and found that only Black Lives Matter was most effective at shifting public consciousness. There have been evaluations about the value of coolness. What does it mean to be cool? How do we know what coolness is? They polled, this poll was done globally, and you have this kind of consensus that folks of color tend to be cool. Something about the ability to exhibit one's authenticity in the face of hostility, in the face of disdain, exhibit a level of calmness, of composure in the face of great strain, and folks of color have had to navigate that terrain. And so these, and this is obviously in tandem with what my colleagues have talked about with the rise of DEI programs, with the challenging of white supremacist curricula, with the policing of language. So all of these things are seen as an affront to white supremacy, are seen as agitation, are seen as questioning the rectitude of white supremacy in a way that has not historically been done at a global cultural level. And so agitation against white supremacy is on the rise. We've seen this, I think, proliferate in the last 5 years, certainly post George Floyd, where you saw this kind of spontaneous, organic movement that happened globally about the value of Black lives and kind of asserting value there in a way that had not historically happened, and social media has kind of amplified this, right? And so we're seeing now this backlash, this white lash, as it is characterized, right? And we're seeing it in all of the ways that we know it behaves, right? We're seeing a surge in violence, and I'm going back a couple of decades here. I'm thinking about the mass shooting at Mother Emanuel at the Buffalo Church. I'm thinking about the language about Haitians eating pets by the now president, then a candidate. I'm thinking about the speeches that J.D. Vance has made recently about being conquerors, about being inheritors of this great legacy, about being descended from pilgrims. And so you have both this rhetoric and this endorsement by highly public political officials about the valorization of whiteness, and also in coupling or jointly with this kind of vigilante political violence, right? But this kind of enforcement of white supremacy, right? This elevation of white supremacy through these very violent and explicitly hostile, racist orientations is not sustainable. White supremacy is known to shapeshift, as we've already talked about, right? It is adaptable, and its priority is surviving, right? And one of the ways that it is able to do that is by employing ambassadors for white supremacy, what I call supremacist ambassadors, right? Honorary whites, people who are able to espouse these same values, but they do so with the level of moral authority that's associated with racial marginalization, right? As a way to insulate critique, as a way to provide cover for and legitimacy to some of these ideas. Because if someone of color is saying it, then it can't be racist, right? Then they have an authenticity, they can draw on whatever cultural, social currency that other folks of color have in advancing this particular agenda. This is also an opportunity for folks of color who may not otherwise have the level of visibility or funding or support or political or career opportunities to get them, right? So this came up when I was teaching critical race theory and a student challenged the alienability characterization in Professor Cheryl Harris's Whiteness is Property. We were getting to the part where Professor Harris says that whiteness is property even though it's not alienable. And this student, who I adored, who had already said he thought I was one of his smartest professors. So I knew he knew what he was talking about, obviously, when he said that he disagreed with Professor Harris. So I had reservations because while I appreciated his insights, I did not appreciate him going against Professor Harris. So I think kind of in a knee-jerk way, I was like, what do you mean? And he's like, well, Justice Clarence Thomas has the ability to move through the world with the protection of whiteness. And Justice Thomas represents, the student argued, an example of whiteness being alienable, right? He has whiteness on his own kind of thing. And I said, well, I'm not sure that's correct. If anything, perhaps Justice Thomas is an agent, but he does not possess whiteness on his own, cannot use it, it is tethered to something else. But I thought more about what it was Joshua was trying to say. Under what circumstances could whiteness be alienable, right? And I thought about this in particular around the discourse that proliferated around the election about the number of folks of color who voted for Donald Trump and the gains he made in communities of color and the emphasis on this aspect of the election as part of the discourse. And what I came up with, right, what I wanted to think about was in the way that Justice Thomas is a public figure, his opinions in Supreme Court decisions have kind of conveyed to the public his ideological alignment. That is what Joshua was attempting to suggest has alienability. It is the public curation of one's ideological alignment, right? By publicly signifying where my racial ideological alignment is, I can use that ideology in a way similar to how a phenotype has functioned in the past, right? And so before you would have needed to present as a white body, but in the era of social media where one can cultivate and curate their own identity in this very public platform, it gives you an opportunity to signify where you are and who you are beyond just phenotype. And one of the ways we're seeing that used is through this kind of racial performance of one's identity, right? And so what I kind of settled on are two things that made me reconsider and think perhaps Joshua was onto something here, which is that publicly curated personas allow one to express allegiance to ideology in a way that can function as a signifier in the same way that phenotype or skin complexion would have functioned in the era of passing. And then secondly, the argument that I made to Joshua was that Justice Thomas's participation or wielding of whiteness or white supremacy could be revoked at any time. And the more I thought about it, the more I realized that was also true for folks who present as white. That we have a history of folks who present as white aligning themselves with anti-white supremacy causes or anti-racist causes and having some measure of their protection, inclusion, or whatever revoked. And I use up here Jim Reeb and Viola Liuzzo because I think that those are really, really famous examples of people who took a very public stance, who showed up at civil rights movement, who walked hand in hand. Mr. Liuzzo was in the car driving people back from organizing for voting rights when she was murdered by the Klan. And there was an FBI informant in the car. That's how we know that she was murdered by the Klan, because an FBI informant was with the Klan. And so we have a history of where folks will signify publicly their alignment with racial justice causes, and in doing so, some measure of their protection is thus revoked, right? The FBI would go on to spread rumors about her. They also did this to Jean Seberg. There's a bunch of examples of this happening, right? And so what we have, we talked about this already. What we have is this opportunity. Social media creates this unique opportunity in the way that these high-profile figures, Justice Thomas or Jim Grebe, were able to publicly signify. Social media now allows everyone to do this on some level who would like, right? It allows us to use identity as a public spectacle, as a signifier, right? And so this increases accessibility to the wielding of white supremacy in this way, and I want to make sure I say that. One of the ways that I'm kind of riffing on Professor Harris's analysis here is, instead of thinking of whiteness in terms of phenotype as a form of property, I am thinking of white supremacy ideology and allegiance and the public signifying of it as a form of property, right? As a way to signal alignment in order to receive benefits that are usually reserved for people who identify as white, right? And so where assimilation used to happen in terms of just presenting as white and being quiet, as long as you could convince white power structures. In Professor Harris's article, it's the hiring manager at a fancy department store, but it could be a political operative who's looking for a voice to elevate for a particular political purpose. I'm thinking like Herschel Walker kind of thing, right? And so it allows you to prove that you are in alignment, that you belong through this kind of public persona curation, right? So now one's public proof is the posts that you make, the pictures that you make, the events you go to, the way you say certain things online as a form of assimilation, right? Instead of the quiet resignation that Professor Harris talks about her grandmother having to endure, where a racist comment is made in her presence and she just has to quietly allow it to happen, what we instead now have is the exaggerated performance of this racial alignment, and I'll give some specific examples here. You know, you will have disparaging and avoiding ethnic markers like a particular hairstyle or a way of dress, or naming one's children in a certain way. You will have valorizing attributes associated with whiteness. We see Candace Owens doing this quite a bit, where she talks disparagingly about Black music and Black dressing and the way Black women show up and this kind of thing. Cultivating predominantly white social connections. We see this with, after Charlie Kirk died, Candace Owens posted videos with he and her, you know, and kept asserting how close they were and how much she loved him, even as people continuously talked about him as a white supremacist, right? Social media is also a closed universe where you can bestow these benefits without actually conferring any real power, right? This person may have influence, this person may have funding, but when Candace Owens started saying, being very anti-Israel, she was not given any power to change anything, right? In fact, that was kind of downplayed. And then you have the ease of recognition and revocation. This is also a way to facilitate acknowledgement and punishment when necessary, right? I think this kind of property is best characterized as like a tenancy at will. It's informal, it's conditional, it has legal dimensions that's governed by traditions, but it's also very precarious and unstable. One of the ways in which I think my analysis needs help is a lot of the social media aspect is social and not legal recognition, although there are a couple of things that we've seen. So there's an increasing blurring between corporate power and legal power in this moment, especially as it relates to social media. I'm thinking about TikTok. These people who behave in this way are also receive some leniency from the law. I'm thinking about Eric Adams here as an example. And then obviously SFFA, where you have this kind of Asian Americans could be seen as being used as a wedge group here, as a group to still purvey the message of the guy who was the orchestrator of this, who was a white man. I'm thinking of Mr. Bloom. while simultaneously, though, insulating himself to some extent from the criticism of racism by using a community of color in this way, or by funding a community of color to kind of advance his agenda. And then I also want to acknowledge some degree of agency on the part of the people doing this. One of the things Professor Harris talks about in her work is the way in which white supremacy denies folks of color the opportunity to choose and cultivate and curate their own identity. And to some extent, this process in social media is responsive to that. Thank you.
So thank you so much to all of our panelists. I want to open it up to Q&A. Folks have any questions they would like to engage on? Yes.
I have a slew of them, but I don't really know. Well, first of all, I will start with a comment, which I think runs across all of your presentations about the irony of not being able to acknowledge, accept, or declare racism when it's not affecting whiteness, right? So before it was like, there is no such thing as racism. What are we even talking about? And then being able to now articulate the feeling of discomfort, right? Where it's like, it's now anti-white racism. Well, okay, how is that possible when we don't know what it is. We don't know how it feels. And so for me, I think it's quite ironic, and it dictates a little bit about this shift that we're all talking about, that in order for there to be some recognition, we need interest convergence, right? Like, we need for them to feel deprivileged in order to recognize this idea of racism or subordination, which is really not what's happening, as we all know, right? Anti-white racism is not a real thing. However, the discomfort of feeling like you are losing something makes you realize or recognize that, oh wait, this could be a thing. I think that should be amplified in the work, right? That this irony that we all sort of know, but because we know it and we feel it, we don't really make it clear. Like, but we need to make it clear that, like, you can't pick and choose when you want to recognize racism, right, and its existence and its visceral nature until your interests sort of converge or diverge, however you want to articulate that. So I just wanted to frame that. I wanted to follow up about what's going on in South Africa, particularly with the refugees, asylees, like, I'm not sure what to, like, I really know what to call them, right? Americanas with the K, I guess, I don't know. And I wanted you to sort of shed light on what the sense is on the ground, because we're sort of on the receiving end, we've seen it happen in the debacle, but you're on the ground, and what are South Africans, particularly Black South Africans, saying or feeling or thinking about what is going on? It is a spectacle, I mean, if we want to be honest, but I want to know what their thoughts are.
For sure. So
I was wondering if we could get all the questions out and then they all respond at the end, maybe in the last 10 minutes, just because I think we may not be able to get everybody's questions if we respond one at a time.
Let's do rounds of 3. So does that work for the panel? Okay, so we'll take three questions at a time.
I just want to make a comment. I really appreciated tonight's presentation. Brooke, it's a really interesting combination of race and religion. I want to make sure I understand it right, where the way I've been thinking about race lately is as an aggregation, a way to aggregate populations to control access to resources. And what it sounds like you're saying is, yes, that's true, and we can subdivide at a lower level based on religion. So we go into a country and separate the indigenous by Christian versus Muslim, whatever. I don't know if it'd be interesting to hear you comment on that. And then just to comment on, the heathen as another way to kind of subdivide people. Just thinking about Obama, he was a Muslim, right? Like, and so, and then just last thing, when he started quoting Clarence Thomas, your side eye was
Yeah, you
amazing.
couldn't hide that.
Great, thank you. And one more for this round.
Thanks, great panel. I also had a question for Brooke. I thought your presentation was great, and I'm so interested in what you think about the laws that were passed even before independence, right? There were at least 3 states that had to pass laws to say baptism doesn't equal manumission. So how does that fit? I don't know a lot about the history of why they passed those laws, but I'm interested in if you can shed any light on that, but also in how this fits into your theories about religion and oppression and white supremacy.
Great, do you want to take that?
Yeah, I'll take that. So yes.
Oh, I didn't need to jump the queue. We were coming up.
Well, we can work backwards.
On the third one, okay.
It's kind of connected. So to the idea of the reason why they said baptism isn't enough because slaves or the enslaved were getting baptized. Because you couldn't enslave your fellow Christian before, so then the people who were enslaved were getting baptized and like, oh wait, no, I can't lose my property.
Right.
So that's not enough. You know, you then follows the line of your mother. If your mother was enslaved, then you become enslaved. And so that goes to, again, to this idea though, that in order to be Christian properly, you have to ultimately be white. And then if you're white properly, then you have to be Christian. And so that is kind of the history of that. But then that ties into, again, what does it mean to be properly Christian, properly white? You ask the question of the subdividing, is race, you go and divide by race and then by religion. It's the beauty of the word heathen, as a precursor, is that it lumps all of them together. There is no race. It says y'all are just not white, y'all are heathen, we gotta save you. Race comes on later and sort of further explains and creates hierarchies within those non-white groups or non-heathen groups. But you come in and you sort of divide them by their religion, and then you start using race as a replacement in that. I don't know if I answered. Oh, and then yes, to the question of Obama as a heathen, again, he can't be a Christian, even though he goes to Trinity UCC in Chicago with Jeremiah Wright, and his children were baptized and all of that, because he is, again, he's not white, he's not fully white, right? And his father had the, I don't even know if his father had a Muslim background, but he also, he's not white, therefore he cannot be properly Christian, he's suspect. And of course, he's not, it's racist and what it should be.
Ohene, if you want to answer the
Sure.
question about.
Yeah, so thanks for the question. To be honest, I live in Pretoria, and just for context, Pretoria is still a very white Afrikaans city. So all the doctors that I go to, like physical therapists, are all white. And between me and my mother, just interacting with them, even they find it hilarious that white people would think that not only are they like being discriminated against, but they should actually qualify for refugee status for a so-called genocide happening in South Africa. So even for white people, it's wild. And as for black people, as for black people, we have like, we have all these memes, we have all these memes and TikToks that are just
Please send them to me.
I would love to curate my TikTok to South African TikTok.
If you want to be in a group chat, just say that.
That's how we deal with things in South Africa through comedy. So people mostly just made a joke out of it. Like, this is the most ridiculous thing ever.
Okay, thank you. Okay, we'll take the next 3. So we'll go right here in this middle row.
So it's a fantastic panel. I mean, I can't tell you how much. Daniel, I'm familiar with your work in education in the past. And I really like to hear what you have to say about these Afrikaners, and I'm curious to know more about that term. Brooke, I'm going to center on you because you actually, I teach First Amendment law, and hearing you speak really crystallized why I hate law and religion stuff. It's awesome what you said. Religious liberty was the expansion of white supremacy. I mean, I would just love to hear just more about that. And Bryson, your statement about whiteness as property and then sort of the next step. I'm looking forward to seeing your article on that when you put together. Happy to check it out. I would love to hear a little bit more about. I'm trying to get it right away, but a little bit more about your next step after Cheryl Harris, because some of it was not as clear to me. Where we go in this social media age, and I think that's like sort of like the next frontier in terms of things. But back to you, Brooke. I really did want to hear more about your what do you call it? Your expansion of white supremacy as your expansion of white supremacy being what religious liberty is. I just would like to get a little bit more on that. And I'm looking forward to seeing your. Is it already out? Because I want to use it in my class next semester.
No, I'm still working on it, but I have another article about ministerial exception that.
Okay, I'd love to get that.
Great. The next question right here.
I have a question pointed to Professor Girley and Professor Ghee. After the death of Charlie Kirk, he started going down rabbit holes about religion, and you mentioned that religion was both used as an offensive and defensive tool, right? But it's also a tool of recruitment under like Reuters, right? Reuters, especially like Nick Fuentes, who weaponized Catholicism as a tool to intrigue both incel movements and trad movements, right? And I think that's very dangerous because it kind of combines with both, using this traditionalist way of like looking at, right America in their eyes. Have you looked at also looking at like, religion, especially Catholicism, or like more like traditionalist, conservative Protestant movements as a tool of recruitment as well for especially young white men?
Thank you. One more, right over here.
I also want to say at first that I didn't mean to take over the role of the moderator.
Totally fine.
So I appreciate your grace and taking
great.
it. So I guess I had one question, or try to keep it to a couple questions for each. Well, the first, I'm sure other people are thinking, how do you pronounce your name?
Rashaya.
Rashaya. Whether you're on the market this year because the University of Mississippi is hiring. I'm sure after this back end, you're going to need somebody else.
I'm not on the market till next year.
Oh, I see. That's good.
But I will note it.
Okay, good, great. I wanted to ask a question about this point or make a comment. Your argument reminded me a lot of Eduardo Bonilla Silva's book, Racism Without Racists, especially his thesis at the end that perhaps in the future whiteness will adapt by becoming, whiteness will adapt in the sense that it will broaden the set of people that it allows to benefit from it in order to maintain white supremacy even in a nation with a demographic shift where whites become the numerical minority. And in the same way, it sounds like you're suggesting that whiteness could adapt by becoming alienable with this allegiance to white supremacy as a basis for obtaining a certain set of benefits. But it does still seem as if the relationship to whiteness through white supremacy is still contingent and it's tethered, in the sense that if you stop doing it, or the alignment is compromised, like with Candace Owens' pivot around Israel and the way in which she lost a certain set of benefits, the ownership ends. I would suggest that one reason that Thomas, has stayed on the court and will soon become the longest serving justice in the history of the country is because he knows that once he's no longer on that court, he will get dropped, right? And so his level of importance or positionality is contingent on that, the role. In terms of Brooke, I guess I started thinking a lot about the fact that I drive around Mississippi and I'm seeing these massive crosses all over the place. And my partner and I were having such a hard time explaining why we're not comfortable with this, even though we identify as Christians. And I guess our language was, I think they mean something different. And I wondered what your thoughts were about the significance of these massive crosses across the landscape, particularly in the deep red states. I also wanted to hear more from the South African context as far as, this is my last one, yeah. If you could say more about this idea of this effort of creating people who are free of racial identities and the effort to de-racialize individuals I think some of that relates to the American context as well.
Okay, thank you. Okay, so to sum up the last batch, okay, and moving forward, let's try to stick to questions. Thank you for the engagement. So we have a question for Rashaya on the religious liberty expansion. Oh no, this is for Brooke. On the expansion of white supremacy through religious liberty. For Rashaya, on kind of the, what's the next frontier, after Charlotte Harris. We have a question on sort of recruitment on the religious freedom aspects for Rashaya and Brooke. And yes, this the most recent comments as well. So hopefully that encapsulates everything.
I don't mind starting. So just to give some, I actually want to go back to what Ariella Gross said this morning, which was interesting, where she said that race neutrality always existed side by side of white supremacy. And that's really interesting because in the South African context, we've always thought of those two as slightly different. So we've had the sort of overt type of white supremacy, which was at its height during apartheid, was obviously the idea that whites are superior to blacks. But even during apartheid, we had white liberals who said that they were opposed to apartheid, but Steve Biko, I don't know how familiar people are with Steve Biko, but he was a founder of the Black Consciousness Movement, and what is interesting was that his main critique was not against the overt white racists who were at the head of the apartheid state, but rather the white liberals. And in post-apartheid South Africa, there's been a sort of split between people who have more traditional Afrikaner values, like the Freedom Front Plus, which is a specific political party that's always had much fewer votes than the Democratic Alliance. But we're seeing, as there's this global shift to the right, we're seeing that even the Democratic Alliance, who have always been white liberals, as opposed to like racists in the proper sense, are now shifting. We're now seeing a weird thing where they both are, it's like like they're both not adapting to a very racist stance and also using white liberal language. But it's like, I like what someone said about shape-shifting and even what you were saying about racism without racist. So what we're seeing now is very tactical. So it's like, if in this context we win by using the colorblind argument, then we use it. If in this context we use this anti-white racism argument, then we go with that. So we're seeing a lot of confusion, and there's not a lot of coherence to the ideology that's being propagated as opposed to previous eras. And I'm mindful of time, but just to say one last thing, there are some groups in South Africa like AfriForum who call themselves a civil rights organization. It's kind of ironic that they use the terminology of civil rights as opposed to constitutional rights or human rights, but we don't use the term civil rights in South Africa. But this is like basically a white nationalist Afrikaner institution. And they had actually, even before now, been trying to propagate this myth that farm murders are somehow some type of genocide happening in South Africa. And they've now claimed this massive victory through the Trump administration's executive order. And this is the first time that they've gained this level of prominence before, which is disturbing, because we used to just think of these people as a joke. Like, there's no genocide happening in South Africa, guys. Like, yeah, but I'll leave it at that.
I'll go real quick. You asked about the expansion of religious liberty. So in looking at, when I was reading through those cases, I'm like, this is just, intuitively, I'm like, this is about white supremacy, right? I grew up in a particular context with evangelicals, and I'm like, I know what this is. I can sense this out. But I then sort of did some research, preliminary research on, okay, out of all the religious liberty cases in the last 20 years, when the court granted for the plaintiff, what was the religion of them? It was more often they were Christian, or at least one Christian in plaintiff, because like the most recent one, Mahmoud, which is about not having your children learn LGBTQ. Mahmoud is Muslim, but there were Christians and Jews also coupled together. So there was that, And then you also see the same players like the Beckett Fund. I don't know if you're all familiar. So the same organizations that are bringing this religious liberty claim. And they're very conservative. They're steeped in this sort of white supremacy legacy. And so they're bringing this as a religious liberty claim, saying that I have a right to, as that coaching prayer, the coach praying on the side. And I just know, again, intuitively, I was like, I don't think if the praying coach was trying to pray to Allah, that they would have the same outcome. I don't think the American Legion case would have been the same if it was the pentagram, right? It wouldn't have even made it to the Supreme Court, and if it did, there's no way that Alito would have written any, Hobby Lobby, the same thing. We're making these exceptions for these Christian organizations to circumvent civil rights law, but here it's just, again, to say that our way of being and our way of life is right because it's Christian and it's white, and to be Christian is to be white, and to be white is Christian. And so I just saw that as sort of an extension of that. I had not considered the recruitment angle, but that would be good to add. And then to your point, no, they're not doing the same thing. It's something totally different. Their assertion is like, this is what it means to be a good white patriot, and I'm, holding up the cross. And it does not include you in that, I don't think, in that concept.
Yeah, so in terms of the next frontier, I think there are just two things that I would say. First, I think this is another illustration of the fact that there's no aspect of society that white supremacy can't and won't leverage, right? Including social media, including religion. Like most of the pictures I see of the Klan, they're in churches, right? They're passing out Bibles, giving donations, right? So it became very clear to me that Christianity was in service to white supremacy more than it was anything else. I think social media is a very similar kind of phenomenon, right? And so there's no aspect they won't use. And then the other thing is, I think nothing is, because there's no aspect, nothing is, you can't take anything at face value, right? So this person may present in this racialized way, or, Christianity may purport these values, or someone may use, CRT language, but if you understand that whiteness is pervasive and rife throughout society, I think it behooves us all to say, in what ways is white supremacy leveraging this tool, this moment, this language, this medium to advance its agenda, and to be really, really, really critical about that. I think one of the ways we've messed up as progressives or as liberals is that we accept their departure point as being race neutral or equality, instead of always defaulting to, this is white supremacy until you prove me wrong, and not, this is neutral until you prove to me it's white supremacy, because what I've seen is it's always the opposite.
With that, we are at time.